Hi, and welcome to our analysis of the January 8, 2010 USCIS Memorandum regarding employer-employee relationships and H1B workers. My name is Reddy Neumann, an immigration attorney with Reddy Neumann, PC, located in Houston, Texas. Before we begin, I need to let you know that the information I'm providing is not to be construed as legal advice for your specific situation. For specific advice on your situation, please contact an attorney. This information should not be construed as legal advice and does not constitute an engagement with Reddy Neumann, PC, or establish an attorney-client relationship. To begin, I'd like to talk about what brought about this memorandum from USCIS. The regulations state that only employers are eligible to file H1B petitions, and the regulations define an employer as a person or entity who engages a person to work in the United States, has an employer-employee relationship, and has a federal tax ID number. Therefore, the eligibility for an H-1B really hinges on the employer-employee relationship. And this is defined as the entity that hires, fires, pays, supervises, or otherwise controls the work of the employee. USCIS considers control the most important of these factors. Before this memo came about, the test for the right to control used previously was developed through the common law. Some of the factors were the skill required for the work, the source of the instrumentalities and tools used on the job, the location of the work, the duration of the relationship, the right to assign additional projects, workers' discretion over when and how to work, the method of payment, and employee benefits. USCIS has found it was difficult to establish the right of control when the employee is placed off-site, so they determined a new test was required, and that's what brought about this new memorandum from January 2010. In the memo, they came up with several new factors for determining the right of control when the employee is placed off-site. The first part includes supervision of the worker. If the worker is off-site, how does the employer supervise the work being done? Are there weekly meetings, day-to-day control? Who provides the instrumentalities and tools? Who has the ability to hire, pay, and fire the worker? One of the newer factors in this new test is whether the employer takes care of the progress reports and performance reviews of the worker. The tax handling of the worker is also considered. Employee benefits is still part of the test. A new part of the test is whether the employee is using the employer's proprietary information at the client location. Also, the USCIS will look at whether the end product being produced by the worker is linked to the employer's line of business. And finally, the test involves looking at who has the control over the manner and means of accomplishing the work. In the memorandum, the USCIS gave several examples for how to determine whether the right of control exists. In one of the examples, they determined that the right of control does exist, and therefore in this example, the employer is eligible to file an H-1B petition. In this example, the employer is a software development company. The worker is contracted to work at client sites to develop an in-house computer program for the client. While doing the worker will use the employer's proprietary software and expertise when developing this program. The worker will report to a manager at the employer on a weekly basis, and the worker is paid by the employer and receives benefits from the employer. Again, in this situation, USCIS has stated that the right to control exists, and therefore this type of company would be eligible to file an H-1B petition. In another example, the USCIS determined that the right to control does not exist, and therefore, in this situation, an H-1B petition would not be allowed. In this example, the employer is a consulting company, which contracts with multiple companies to supply workers. The positions are not specified in the contract, but are staffed on an as-needed basis. In this situation, the worker is filling one of the client's core positions. The worker only reports to the manager at the client site, and work assignments are determined by the client. In addition, the employer has no control over how the tasks are accomplished. The worker does not use any proprietary information or software from the employer. The end product is not related to the employer's line of business, and the client is the one that reviews the performance and reports on the progress of the worker. Again, in this situation, USCIS determined that the right to control does not exist, and therefore that employer is not eligible to sponsor an H1B. Now, if this situation sounds a lot like your company, there are some things that you should consider to make improvements to your business process in order to comply with this memo. Before we get to that part, I want to talk about what types of things the USCIS is going to look for and how they would determine whether this right of control exists. Mainly, once an H1B petition is filed, if it is seen that the worker will work off-site at a client location, most likely USCIS will issue a request for evidence, or RFE, asking for various documents so that it can consider whether the right to control exists. In these RFEs, USCIS will ask for an itinerary that specifies the work locations, the dates, and the client's names. This is not something new. Most of the RFEs we've been seeing over at least the past year have been requesting this specifically. In addition, they'll be asking for employment agreements and offer letters. Again, this is not new either. They'll also be asking for client contracts. We provide these on a routine basis in response to RFEs, but they'll probably be looking at these contracts in much more detail to see whether the contracts themselves state who has the right to control. They'll also be asking for work orders and letters from the end client, which is normal. We've been seeing that over the past year, but it's likely that they'll want more detail in the client letters, asking for who really supervises the employee while they're on site. They'll probably be wanting more detailed descriptions of the position that the worker will be doing, and also a description of the employment relationship. How, in your terms, are you going to describe this relationship to USCIS so that they will find that an employer-employee relationship does in fact exist? One of the new things that they'll be asking for is a description of your performance review process. This will help show them that you do have control over the employee. You are the one determining whether they should be fired, whether they should get a raise, whether they should be promoted or demoted, for example. Finally, they're likely to ask for organizational chart because they want to see who is supervising the employee when they're at the client site and whether any employees are going to be reporting to the beneficiary or the employee as well. Now, that list that I just mentioned was mainly for H1B transfers or new H1B employment. In the situation where you're filing an H1B extension for the same employer, they're going to be asking for more documents because they want to confirm that during the previous H1B period, while they were working for your company, did the right to control exist? If they determine that the right to control did not exist previously, it's possible that they will deny the H1B extension petition for this reason. So in order to make that determination, they'll be asking for pay records, which is nothing new. They've been asking for that before to show maintenance of status. Also W-2s. Now they're going to be asking more for timesheets and work schedules, examples of work produced, and some of the examples for types of documents that you can provide in this situation they've mentioned are blueprints, newspaper articles regarding the employee's work, or any descriptions of the project they've been working on. So this one will have to look into the details of the project to see what documents or information can be provided. Another new one for extensions, they're going to be asking for copies of dated performance reviews. They want to see that during the previous 3-year period of your H1B petition that you've been regularly looking into the performance of the employee and documenting their performance and progress. Finally, they'll ask for employment history records, which is more of probably a catch-all for all of the documents they'll be asking for. For example, if you have issued your employee a letter of congratulations for good work on a project that they carried out, that would be something you would keep in your files, and you could provide that as documentation of your employer-employee relationship.